I am Yunchi van der Sype from ICRI KU Leuven, and we are an interdisciplinary center for IT and IP law. And as part of my job, I had this wonderful opportunity to organize this panel with the backing of the MUSES project. MUSES stands for Multi-Platform Usable Endpoint Security, and the goal of MUSES is to develop a security system that helps companies to better protect their company data assets, but with the user at heart, so with respect for their privacy. Thanks to the work done in the MUSES project, we thought it would be a good idea to organize this panel at the CPDP conference. And as we all know, there are many different interests at stake in the work organization. There is the privacy of the employee, but also the interests of employers, of colleagues, and consumers, third parties, and so on. And this brings me to the first topic of today's panel, that being the balance between privacy and data protection and the rights and freedoms of others. This discussion will be followed by a more specific analysis on the importance of sanctioning risks and the complications regarding data transfers to third countries. During this discussion, the panelists will allude to the reforms that are proposed in the draft general data protection regulation. And I will now give the floor to Estelle Massé, who will lead the discussion from.
Thank you and welcome everyone. We're going to start our first discussion on the balancing the right to privacy with freedom of others. We have the chance this morning to have a very good panel with Stephanie Raets, lawyer and senior associate at the law firm Claeys and Engels. Thank you for coming. Nigel, European legal director at Coca-Cola Enterprise. Thank you. Walid Maalej, professor of informatics at the University of Hamburg. Thanks for being here. And Professor Hendrickx from the University of Leuven. So as Yunjing told you, the discussion this morning will be separate in 3 different topics. The first one being balancing the rights to privacy with the freedom of others, then the sanction issue, and then the challenge of data transfers. For each session, the panelists will be discussing for about 15-20 minutes, and we would like it to make it interactive with you. So if you have any question during any of this session, please feel free to raise your hand, and we'll make sure that you can participate in the discussion. So without further ado, let's start with our first panelist. Maybe Frank, you can launch the discussion on balancing the right to privacy.
Thank you and good morning, everybody. Well, at the time when I was writing about privacy in the workplace, it was 15 years ago when I was writing my PhD, I remember that it was not so evident to introduce the privacy concepts in a workplace area and in employment law. And so what was new was to deal with what I call the 3 main principles of legitimate aim, of interference with privacy, the principle of, you can say, transparency or having a legal basis to interfere with the privacy, and the proportionality aspects. And so the application of human rights approaches into the employment context led a little bit to a discussion. And the funny thing was that when I was defending my PhD, and when we're talking about balance and imbalance, some people of the jury said, well, Frank, by introducing those fundamental rights protection mechanisms in a private context of employment, it leads you to being a fundamentalist, a privacy fundi. And I also remember another part of the panel saying, well, actually, what you are doing is making a balance between privacy and employers' interests, ultimately, because employers also have legitimate interests to be able to show. So actually, what you're doing is ultimately giving away privacy of employees, because the employment context, as you argue, is a different context than your private context. And so the balance, I think, at a level of general principle can always be struck in a fair way. So for me, I do not immediately see a problem with balancing. I think the tools, for the moment, are there to do that at a very abstract level. Now, what I see also is, and I've looked recently again at the case law of the European Court on Human Rights, and you see that employment privacy, employee privacy, is really a growing and a broadening area. For example, there are cases where the court says, the Human Rights Court in Strasbourg says, well, privacy protection also means when employees are dismissed because of activities in their private sphere, well, that comes under the privacy protection under Article 8 of the European Convention. So ultimately, a sort of dismissal protection also falls under Article 8 and under a privacy protection. So a very broad idea. Information that is asked in a recruitment process, in case law of the European Court of Human Rights, the court also has said, well, a ban on employment, saying you refuse people for employment because of things that they have done in the past in their private context, that refusal of employment to people also comes under the protection of privacy. So what you see is actually a very broad idea of privacy in the eyes, at least at European level, at the European Court of Human Rights. And I think some people would say, well, this goes too far. How far can we go by protecting rights in an employment context under the concept of privacy? Other things that I want to mention and to start up a little bit the debate is the fact that when we talk about the employment context, and if I look at the case law, at least at an abstract level and also at the level of the European Court on Human Rights, the court has developed a notion of reasonable privacy expectations. And the strange thing, of course, is that in an employment context, you can say employers have the rights to supervise an employee, to control employees, to exercise their authority. And so they have a right as employer to not to leave the employee alone, where the right to be left alone is also present. And the court, a little bit based, I think, on the American case law in the Supreme Court in the States, has developed a reasonable privacy expectation notion that has come up in cases also when there is a case of employee monitoring. For example, a telephone tap, the Halford case, therefore, is illustrative. A telephone tap could be organized as long as the employee is properly warned on beforehand and has been given information about the privacy interference that is going to take place. And thus the employee must have or can have a reasonable privacy expectation. And I think some commentators in the literature already have indicated the danger also of that notion, because again, you start to get sort of flexible discussion on to what extent do we have privacy? Well, the answer could be to the extent only that you have a reasonable expectation of privacy. And what then does that mean in an employment context? So let's say abstract, and in the context of human rights protection, the principles are very abstract to make the balance. And because they can be molded a little bit, it can go in sort of any direction ultimately. That's my feeling of the case law. The problems of balance, in my opinion, rather come when you start to make very concrete rules on privacy protection. And perhaps we will hear immediately also cases from Belgium. But if you look at, for example, the Belgian context, where you have very specific privacy and data and employment privacy regulation, you get sometimes cases where you say, well, this is not fair. The result is not fair, and you get then very complicated discussions, which we'll deal with maybe later about admissibility of evidence in court and so on. So at an abstract level, the balance of privacy seems to be able to be struck in a fair way, but it's still very flexible and open.
Thank you, Frank. Maybe, yeah, Stephanie, you want to...
Maybe I don't entirely agree with you, Frank. I think on a Belgian level, you're right, and on a European level, you're probably right. But in my practice as a lawyer, I've been dealing with data protection and privacy issues for about 10 years now. And I also had the opportunity to talk with other European colleagues about this matter. And so I know for a fact, for instance, that in Portugal, if you want to use evidence that you obtain by e-monitoring, for instance, when you have dismissed or you want to dismiss an employee for serious cause, you cannot use it. The Portuguese case law always puts aside the evidence obtained when any privacy or data protection rule is violated. Before 2008 in Belgium, it was the same way. And so indeed, I agree that that was no longer feasible, and so the case law has also in Belgium and also at European level, there's a trend in case law where they say you have to make a reasonable privacy expectation balance and see what kind of infringement did the employee commit, and can the evidence be used by the employer. But in a lot of situations, it's still a very complicated matter. We have specific regulations in Belgium, and I think maybe a good case to demonstrate is a client contacted me a couple of months ago. He suspected a number of employees to to be guilty of an unfair competition scheme. And he said, and I'm sure that when we examine their laptops, that we're going to find evidence, but you know, in Belgium there's a national collective bargaining agreement that states if you want to examine irregularities committed by your employees, you have to do that in 2 stages, and in the first stage you cannot individualize who has committed the infringement. So you can only examine data that are global, and then you have to send an email to all your employees to warn them that you are examining an infringement, and that you have that you presume that somebody is guilty of that infringement, and that if another suspicion of this irregularity occurs, that you are going to individualize who has committed it. You know, in practice that's not feasible. So my client said, I have a good idea. I'm going to ask the 3 employees that I suspect of committing this unfair competition scheme to return their laptops to the IT department for maintenance. And so I asked him, but do you do that on a regular basis? Oh no, we never do it. They only have to return their laptops when there's a problem with their laptops. So I said, I don't think that's a very good idea in the scope of the principle of transparency. I think that can be used by those employees in a later stage to say that you have examined the laptops under a false pretense. So in practice, employers have always had the need to secure their corporate information, and now I think a lot of it is e-monitoring, and in practice I still experience an imbalance because the employers are still restricted by the regulations to which extent and how they can examine the e-monitoring, the electronic communication.
Yeah, I just wanted to add and build on that, particularly around the issue of transparency. At Coca-Cola, the focus very much, and to get the balance right, is very much around clear communication and messaging around our policies and processes, and what we are going to monitor and what we wouldn't monitor. So the very foundation of our approach with our employees is very much about an understanding from our employees on what they should expect is not going to be private within the workplace. So at Coca-Cola, for example, they will know that through our IT policy, through our code of business conduct as well, that company emails, they should expect that they could be open to being monitored. But it's all about checks and balances. It's all about making sure that when we do investigate and we do monitor emails and we do look into, we do investigate a matter, that it's done in a way that it's done when there is just cause to do so. And this is something that's been built up with agreement with our union, the works councils in each country. It's not just Belgium, but all across our various territories in Europe. We've agreed policies with our works councils, with our local representatives, to make sure that it's clear that there's an understanding that we will monitor and investigate where we have good grounds to believe there's suspicious activity. So I think it's all about setting the boundaries and clear messaging, and that's my experience from the company.
So I would like also to comment on especially what Frank said. So I am a system guy, I'm a software engineer guy, so I'd like first of all to understand a little bit what actually the problem is about, and that's how we work. Yeah, so that's how we start. And for me, first of all, I'd like to perhaps try to, as I said, put the to make this a little bit explicit. So what do we balance actually? What do we want to balance between what? I would like to do this basically based on 2 examples. The first example is what I call physical privacy or something like that. So imagine you put a camera in, let's say, in Coca-Cola or in a different company, where, because as a company you would like to make sure that nothing got stolen, or you don't have some bad people trying to get into the company and steal something, or So this is of course a legitimate purpose to protect your so-called company assets. And so that's the first example. So as I said, that's so basically collecting, or this could be of a risk for the as I said, what I call physical privacy of the people. Yeah. The second example, or the second type of where we could have such kind of imbalance or threat, is what I call virtual privacy. So basically, this is everything that is about the knowledge workers. So when people really work with their computers, not the ones who fill the canes, or anyway, the robots fill the cane, but not the one who are really basically doing the physical work, but the one who are really sitting in front of the computer and writing emails and making phone calls and things like this. So he has, of course, also, you could say, in this case, we have we can also collect the data about, for example, you want to protect the patents, for example, in the company, or we want to protect some communication and emails with the customers, and so on and so forth. And I would like to take these two examples also to show how the imbalance could be. So in the first example, where we have a camera, let's say, as I said, in the court of the company or somewhere, you could, of course, take this as an argument to say, hey, I would like to protect the assets, but you could also take the camera to look or to film your employee during their break, where, for example, while they're smoking. You could derive out of this, hey, this is the health situation of these employees, and maybe those who don't smoke don't get the bonus, and those who smoke don't get the bonus. Then here's, for me, I'm not a lawyer again, but I would say with my normal citizen logic, I would say this is not okay. And for the second example, also the same. Yeah. So for example, my employer, I'm working at the university. My employer say, okay, you can actually, during your work, you can also use the call in the phone. This is okay for us. You could use the phone, or you can use your email to call your wife. So I can call my wife, for example, during the break again. And so I could say it's okay that my company or my university make sure that we don't get some data stolen, but it's not okay when I call my wife, or when I write an email to my wife. I don't really want that this information that I'm going to talk about is going to be collected. And exactly here I see these two examples make it for me clear where the imbalance is. And now I would like quickly to say how I a little bit disagree also with Frank, since you said at the beginning that you don't see a problem with the tools. And I personally see a big problem with the tools, because exactly on these two examples. So if you take the camera cannot distinguish. So for me, a tool is at the beginning also a technical tool. And I think the camera cannot distinguish whether she is right now, or it is right now, filming or getting a threat to the company since someone is getting in, or the camera is collecting information about the people who are making a cigarette break or something like this. And the second example as well, the computer does not distinguish that the employee is right now basically chatting or talking to his or her wife, or the employee is right now working with patent and high security sensitive issues. So I think also we have a problem with the tools. I think we have a problem with the proportionality. Okay, how can we say that this is proportional and this makes sense or not? And also the tools, how can we do it?
Thank you, Walid. Yeah,
Sorry.
I will let you.
Sorry, can I just in the company, what we find is it's all, again, it goes back to making sure that there are proper checks in place. So what happens in our company is, if we've got a suspicion about somebody, let's say there's a suspicion about a theft or some other activity of that, a suspicious activity, then the way it would work is that we would have a cross-functional assessment of that. So it would be our risk and compliance team, legal, HR, IT may be involved as well, and there would need to be a business case developed before we go through a process of actually doing some kind of monitoring. So even though our policies will say we have the right to monitor your email or this or that, in practice, that right would only be exercised on an exceptional basis when there is a clear business case and then a clear approval process from a quite senior level. So it's all about restraint and not taking advantage of the rights that you set out in your policy. It's also about having the strong and robust grounds for doing that, and that's how I think we get the balance fairly right in our company. But yeah.
If I just may add a few things, my proposition was that I think at the abstract level, from what I also see happening in the case law at a human rights court, the principles that they deal with, which are quite evident principles, do not seem to lead to very problematic situations in balancing the two things, privacy of employees and business interests, let's say. But I agree that, and that's also my point, if you go into a very concrete national system, and I will use the case of our highest court, the Cour de Cassation, where we had to deal, it's the case of 2001, before we had those very practical, detailed rules of the collective partners on email and camera monitoring, where you have a suspicion of theft and an employer says, well, I want to know what's going on and I want to install a secret camera monitoring system to bring the evidence to the police and to the authorities. Well, in such a case, the court, without having to deal with very concrete, precise rules of the collective agreement that is now applicable, before that was applicable, was quite flexible in assessing the, let's say, the expectations that employees in such a case have. They don't have these expectations of privacy anymore at that point. And I thought it was a fair balance. At the moment, indeed, when you, as Stephanie correctly indicates, when you get into very precise principles where you want to say, we want at before and at an abstract level, but more precisely regulate employment privacy, you get into trouble. So I rather prefer the abstract principles than going into very detailed rules of regulations of privacy, which lead ultimately to cases where you say we cannot apply them anymore. And then you get a big discussion before the employment tribunals on the admissibility of the evidence, yes or no. And then indeed you get cases like perhaps the Portuguese case, but also in Belgium, where courts say, well, then we don't accept the evidence anymore. And I think this is unfair. So I rather would go more abstract than regulating in a very detailed way.
Thank you. Before we move to another topic, I would like to ask our panelists a little bit more detailed about consent, employees' consent, because we've been talking about employees' expectation and policies in place in companies of what employees could expect to be monitored or what their device could be accessed. But we haven't touched on the issue of employees' consent, which is also a big part of the future data protection regulation. And I would like to get your views on how employers should or should not ask consent, and what's the practices in place at the moment in your companies or in your experience.
Yeah, maybe I could elaborate a bit on that, because indeed that's a recurring question for me as a data protection lawyer from various countries, from US companies also. Can we just ask our employees, can we just give them a notice of data processing, and underneath the notice it is mentioned that he consents with the processing of his personal data? Is that sufficient? Well, from a Belgian point of view, I always say try to use consent, do it, ask for consent, but try to use it as a secondary basis for the lawfulness of the processing. That is based on the directive, on the Belgian legislation, and it's also scoped within the future proposed data GDPR, I believe. Because I think in the majority of the cases, an employer will have another legitimate aim to process personal data, and that is the very vaguely described one of the legitimate interests of the employer, as long as those interests are not overridden by the employee's privacy interests. So in the majority of the cases, e-monitoring, etc., I think that's a sufficient cover. But on the other hand, in all those regulations, the employer has to inform its employees. it has to give information, who is the data processor, which data am I going to process, what are the purposes for the processing, who are the recipients. And so I always advise to combine those two, to give them an information notice, and indeed to put beneath the notice that the employee agrees, consents to the processing of his personal data. Now, under the draft GDPR, there's a lot of discussion. I think this is one of the most debated issues. Can an employee give his consent to the processing of data? And in the initial draft, it was stated no. There's an imbalance between employer and employee. The employee, being in a subordinate relationship, can never consent to the processing of his data because his will not be freely given. And it's stated in the regulation that the consent has to be given in a free way. But now it's already nuanced a bit, I think, and there are amendments suggested lately by the German delegation that says, well, we believe that a general exclusion of employees' consent should not be mentioned in the regulation. Employees should be able to consent to their data processing when it ultimately gives them a legal or economic advantage. And I was thinking about that, and I was thinking, like, I think in the employment relationship, a lot of personal data processing of the employees ultimately leads to giving them an advantage, giving them the advantage of being employed, giving them advantage of a payroll. All data processing in the scope of payroll administration leads to the advantage of giving them a salary in return for the work performed. So what remains, I think, is monitoring. The thing that does not lead directly to an advantage is monitoring by employers, and for that I believe that the legitimate purposes pursued by the employer should be a sufficient legal basis to cover it. I don't know what my fellow panelists think about it.
No, I completely share what you've just said, Stephanie, and just to add as well that as well as agreeing to policies, what we do is make sure that our employees have read and they give some kind of written confirmation that they've read and acknowledged the content of the policies, so that we have the assurance beyond the employment contract. The other point just to make as well, just to add to what you've just said, Stephanie, as well, is that in some countries, I think maybe in all the countries we operate, we will also have consultation and consent from the works councils or the local employee elected representatives in each of our countries to the IT policy that we've got, the social media policy, data protection policy, etc. So. But I completely agree with what you've just said.
Well, a few things to add, if I may, is, in my view, I agree that the idea that employees can never give their consent is a little bit a sort of underestimation also of the possibilities to give consent actually in practice as being an employee. I remember the case law in Belgium where the Cour de Cassation had to deal with the question, can an employee, because he's not free to accept employment in some cases because he's just in need of work and he needs to sign an employment contract, can he argue that he was not free to sign and therefore the contract is null and void? The court said, well, the economic, let's say, subordination that an employee suffers from is never a case to say that his legal, let's say, consent is illegal. So in that sense, I think we should not overdo that. And I agree a little bit with the German position saying that, well, you should not have a general exclusion of employee consent. I think consent has to respond to a certain number of conditions. You have, of course, to have informed consent. I think it's very important that people know what they are giving their agreement for. We also have built up in the past a sort of concept that it has to be a specific consent when employees want to give away a few things. This comes from the personality rights movement in the past, where also cases have been envisaged of intellectual property rights, where employees sometimes give away their rights from, or from other personality rights. And these cases have been emerging in cases where you deal with movie stars and photos of public people who are then later used by other people. So it must be a specific, well, framed consent, let's say. And I once have also suggested what I call the double-layered sort of legal basis, where you have consent, which is backed up by agreement with, well, workers' representatives in the enterprise, which is not something that is done a lot in practice, I think. But if you look, for example, in the Belgian legislation on works councils, in principle, the works council is competent to deal with employment privacy issues. So you could have a sort of double-layered consent backed up by collective partners in the enterprise. One thing I want also to say is consent should not be overestimated in practice, because in many cases you deal with existing employees and you say, well, we take consent as an access to process data. You can also get a no by your employees. Say, what do you do if half of the employees say, no, you cannot process my data? Are you going to dismiss them? No, that's not what you want to do, because employers are on their knees to keep their employees who are good. So you also have that problem in practice, I suppose, in an enterprise context.
Thank you. Thank you for this first discussion on this topic. I think we're going to move now to the second topic on sanction. While preparing this panel, I think it was a topic particularly of interest for Stephanie. Would you like to start?
Yes. So it's the importance of the sanctioning risk. I brought it up because when I had the opportunity to talk about this subject with a number of my Jus Laboris colleagues, which is an international alliance of labor and employment firms in all kinds of different countries, and it made me realize actually that in Belgium, I already said I'm a data protection lawyer, but I actually am not. I'm a labor and employment lawyer, and I work for the biggest law firm in Belgium in labor and employment law, but we don't have a formal official data protection team. It's something that I do a lot, but we have 80 lawyers, and I'm one of the only ones who deals with these issues on a weekly basis, I think. When I meet my colleagues from Denmark, from Germany, from Ireland, from the UK, they have official data protection teams. So how come, I was wondering that the awareness in those countries of data protection legislation and the willingness of employers, of companies to be compliant with data protection legislation, and it led me to the conclusion it's just a matter of, are the companies or do the employers risk of being sanctioned when they don't comply with the data protection legislation? A good example is actually the duty to register with the local data protection authority. Yeah? As you know, automated processing activities as a general principle have to be registered with the local DPA. In Belgium, I think 80% of the data protection of the processing activities are not registered because nothing happens to it. It's published in a public register and that's it. So in Belgium, the Privacy Commission, our local data protection authority, has no active monitoring nor any sanctioning power. And so I think basically from a lawyer's point of view, that's the question that my clients ask me. If I do or don't do this, do I have a risk of being sanctioned, yes or no? And so if my answer is no, then they say, well, we have a budget and we're going to spend it on other things than being compliant with data protection. And I can agree with them. I think that there's a big difference when you compare it, for instance, to Germany, and maybe Walid can go into that, because in Germany, my colleagues say the companies have a high sanctioning risk, and so they have a high willingness of being compliant with data protection rules, whilst in Belgium, the only risk actually in practice is the risk of evidence being put aside by court. And so I think, and that's what I brought up before in this panel, I think that this might change if the draft of GDPR would come into force as it is now, because a lot of powers are given to local data protection authorities. They will have the power to give administrative fines to companies. It is explicitly stated in the regulation that employees and other data subjects can lodge complaints. The data protection authority should investigate those complaints and should inform the employees on the progress and the outcome of the complaint. So they will have to do something which leads to the fact that companies and employers will have a higher risk of being sanctioned. So I think the data protection awareness and the willingness to be compliant will also increase as a result of that. One side remark before I give the word to my colleagues is that, for instance, the Belgian Data Protection Authority has taken the initiative to advise on the draft GDPR, and it has stated, please no, don't do that to me, don't give me sanctioning power, I don't want it, I don't have the manpower. And the Data Protection Authority has also stated, I don't think that it is in line with the separation of powers. It believes that it should have the power to advise employees, to help employees when they have a problem, to mediate, but it doesn't want to have any sanctioning capacity. It says that's up to the judicial power. So I think it'll also be a question of, is the GDPR going to come into force as it is now? I don't know. There's still a lot of debate going on. And on the other hand, what will the local DPAs do with it? Will there be DPAs that don't exercise their sanctioning capacity? So that's actually my view on that.
Everything that I do is really about assessing the risk to the company, and in many different spheres. When it comes to data privacy, it's true that in some countries the sanction risk is low, and therefore should it be a priority for the company. The challenge for our organisation is that we operate in different countries, including, for example, France and Norway, where the sanction risk is a lot higher. Particularly in France, there are very strong powers on the CNIL, which is the French Data Protection Authority. But it goes beyond just the risk of sanction when we're assessing risk for the business, as well as formal sanctions from an external body. Our concerns as well are about information security, about protecting the company's trade secrets, confidential information, and also protecting our employees' data. For example, if we have a rogue employee who's working in the payroll function who compromises our employees' bank details, then that's going to be a very serious issue. We may not be fined externally, but we're going to have a very serious issue in terms of our employees' personal details being compromised. So it's the protecting our employees' personal data is protecting our staff, as it were, but also on top of that, it's also protecting our company confidential information, non-public information. Trade secrets is another consideration above and beyond the sanctioning powers of some data protection authorities.
So I would like to actually just confirm what you, Stephanie, said also about when we don't really have some clear sanctioning rules, then perhaps it doesn't really make much sense. I would like to give just an example. It's actually not directly related to privacy at work, but it's privacy. So I don't know much about the sanctioning power or the sanctioning rules in Germany when it comes to privacy at work. But I know that when it's about privacy of users, of normal users, for example, when using mobile apps or things like this, then we have in Germany one of the, we think that we have in Germany one of the most detailed laws to protect data privacy. And in Germany, when you, for example, release a software system as a company to your users, you have to do actually when the system is collecting some user data, you have to do two things. You have to do by law, you have to do two things. First is you have to inform your user, so you have to give them some kind of a privacy policy where they agree on it and they know what is being collected and for what. So you have to do this. And the second, so something that, you know, when you download your app from the App Store, it tells you it will connect this and this and know your position and I agree or disagree. And the second thing is you have to, whenever the user asks you what kind of data you are storing in your database, you have to tell them, basically, you have to give them a record of the stored data. So obviously this is enforced by law. So the law says, okay, you have to do this. And we have conducted a study a few months ago. It's not yet published, but it's in the publishing process, in order to understand how many actually of the systems in the market actually comply with this law. Actually, really give inform the users about the data collection and the privacy issues, and really send them also information when they request it. And we really did this. So we really downloaded a sample from the App Store, and we really contacted the companies and created fake accounts and sent them information. And we said, hey, we would like to get our data. And guess what we got is at maximum, after several iterations, maximum half of these apps and half of these companies really reacted or basically made, they had their duties. They did what they have to do. And when we tried to look at this, also when we talked about this to legal experts, and the most important conclusion was actually the reason perhaps is that because there is no clear sanction. What happens if they don't do this? So the law says, okay, you have to do it, but it doesn't say what happens if you don't do it. And that's I think just an example to show this the importance of this point. And also what you said about the manpower, and that's exactly what our experience was about. So when we started also talking about the data protection authorities in Hamburg, where I'm based on, they said, hey, forget about it, because there is simply not enough people and not enough manpower to really deal with all these issues. Yeah, they will not. They simply they will say, hey, try to solve it somehow differently, but not in the court. So that's I think. And finally, just also I really liked also Nigel points when he mentioned that it's not only about sanctioning, but it's also about showing what's the advantages and disadvantages for both sides, maybe. So I think that has to be also taken into the perspectives.
Thanks. I will give the task to France to conclude on that. It's very interesting so far. So we see that there is a high link between sanction and enforcement. Unfortunately, if we have lawmakers here, we realize that just a regulation will not make data protection, even though it's a fundamental right in the EU, apply everywhere. So sanction in the regulation will be important. Frank, if you have something else.
Well, I wanted to say that I'm not sure whether indeed the route of having data protection authorities getting into sort of administrative sanction system, whether that is the most feasible way. If you look at the employment context, maybe at other contexts, yes. What I feel is that the workplace privacy cases mostly have their entry when you start up a legal debate through employment tribunals. The case law that we have discussing most of the time comes into a sort of context of employee wrongdoing, and the employer has collected data maybe on an unlawful basis, and you get a discussion about the acceptability of the evidence before the court, which is very often seen as a sort of element of enforcing the fact that the employer has intruded too much into the privacy of the employee and did not follow the rules. So it's a little bit dependent also then on how your employment law is structured. If you have to deal with a case where an employee is dismissed for a serious cause, well, you have already a specific discussion. If you have to weigh that up against privacy laws that maybe have been violated, but the employee nevertheless has done something completely wrong, then, well, again, you start up with a balance, and you see that there are leaks into the fact that, in principle, a court can reject the evidence, because courts have started to allow evidence in cases. I also believe when you look from the perspective of employment law, and for example, you take a parallel case where you do not have a privacy violation, but, for example, an employer, maybe also in a dismissal case, has discriminated an employee. Most of the time we say, well, the dismissal will take place anyway, but you can then sanction the discrimination that the employer has done. So why do we not go into that route? It's non-existent for the moment. That, like in discrimination cases, you get 6 months pay, a lump sum basis as damages. Why can we not go in that route when we have a privacy violation. That may also lead to dismissal. So maybe we should, well, go further on the employment law principles there instead of going to sort of sanctioning system in a classic way.
Thank you, Frank. Before we move to the third and last topic of this panel, does any of you have any question for our panelists? We can also open the floor after the third panel if you prefer that way, but we'd really like you to contribute to this discussion and share your view or ask any further question you have. Yes?
I'm curious as to, we've sort of been talking about the employer's interest and the employee's interest and speaking of privacy and balancing those, but how do you also, or does the consideration of privacy interests of people who the employer may be collecting data? So for example, it's a company that deals with a lot of personal data from its customers, and the employer needs to monitor for information security purposes to prevent exposition of data which could seriously affect the privacy interests of the customer. Does that change the calculation of the employer's privacy interests versus the, or excuse me, the employee's privacy interests versus the employer when you've got that additional third factor that's other privacy interests?
Can I start? Well, Stephanie will know that also in Belgium we have a big discussion about well, e-monitoring in general, communication monitoring, where we have also criminal law that protects well, the confidentiality of communication. Well, of course, if an employer wants to monitor employees where also customers, clients are involved in the communication, you basically and technically run into some problems because you not only have the rules that apply in the workplace, but also you have the rules protecting the privacy of those customers. And combining those two makes indeed the discussion and the solution also much more complex. And to be honest, under the criminal law provisions that in principle protect communication with clients, also when it's undertaken by employees on behalf of their employer, criminal law protects that confidentiality. And it's very difficult to let's say, to organize a safe route to say, well, under criminal law, you have fully legally basis to both use the communication with external clients for even HR purposes internally in the company. So yes, I think it throws a completely different light on some discussions. Stephanie, I don't know whether you agree with that.
Yeah, I definitely agree with that. And I think the processing of customer data also gives additional difficulties because actually as an employer you also have your duty to inform those customers, and there's a little clause in the directive and also in the draft GDPR that states that only if it's not if it doesn't requires disproportionate efforts from the company to inform the customer. So I think they hide behind it for a big part of the time, and I think it's the biggest issue, and we're going to talk about it a bit later, is transfer of those data. Yeah? So of course, as data controller and processor, you have to have security measures in place to protect those customer data. But talking about onwards transfer to maybe third countries, possibilities of data breaches, I think there are definitely some challenges for the future. Yeah.
Yeah, it's a very important point you raised, and from our perspective, it just shines a light on the importance of employee confidentiality and the responsibilities that the employee has. For example, in our area, in our industry, but in any industry, the information that and the discussions that are had between an employee and a customer obviously cannot be shared with another customer. There are all sorts of other laws that come into play. Competition law is very particularly relevant to Coca-Cola, and so we have to have very clear boundaries and strict rules of confidentiality and information sharing requirements internally and in terms of our discussions with our various customers. So it just puts a spotlight on the fact that yes, employees' privacy has to be respected, but at the same time, employees, by being an employee of a company, has responsibilities and obligations that they have to adhere to.
Thanks. So I think we'll move to the third topic, which was perfectly introduced through this question on transfer of personal data, both for employees and also for customers. And for this question, I think Nigel will be could give us a little overview of the process in Coca-Cola, and namely under the Safe Harbor agreement, and the challenge that your company face on this issue.
So this is an area that is particularly challenging, and it's actually probably the area that I spend most time in terms of work relating to data privacy. The world is becoming ever more global, and the use of we more and more are outsourcing our IT services, some of our HR support services to service providers in outside of Europe, and actually to companies maybe that are head office in the US but are based in India, Philippines, South Africa, etc. And that brings with it challenges around the protection of our employees, not just our employees actually, customer data, supplier data, all personal data that we hold, in terms of making sure that these third-party providers that they who may very well have access to some of that data, or may be able to get access to it because they have to do maybe IT maintenance support, or it's connected to payroll matters, whatever. The challenges of the fact that a lot of these companies and these providers are operating in countries where the European data protection legislation isn't in place. So what we've done, and also separately to that, the way we operate in European territories, but our head office is in Atlanta. So we also have to have internal controls as well in terms of the transfer of personal data between our European subsidiary entities and our head of our main company in the US. So what we've done in terms of internal controls is we've made sure that we have that the US company, our top company, the CCE, Coca-Cola Enterprises Inc., has safe harbor status, which effectively is a certification that gives it the status that it's in compliance with European data privacy rules and regulations, and basically that needs to be updated every year. It's actually not legal that is involved with that. It's our IT department that owns and manages that process. But as well as that, we have individual data processing, data transfer agreements between our head office in Atlanta and each of our European subsidiaries. So that's the way we kind of structure and protect ourselves in terms of our internal company transfers. But beyond that, in terms of dealing with third parties, we've had quite a lot of challenges around, do we have individual data transfer agreements between each of our European subsidiary entities and the service provider that we're using in India or in the Philippines, and we've got different advice on this, and it's not completely clear cut as to whether we take a very conservative approach or a slightly less conservative approach. But the different ways to do the most cautious approach is to enter into model clause data processing agreements between each of our European entities and the service provider in, let's just say, India for ease of reference. And there's quite a lot of work that goes into that, not just in preparing that, but then in notifying, and in some countries getting the authorization of the local data protection authority. The other way to do it is many of these global IT providers who have their subsidiaries in India or in other countries outside of the US or Europe, the head office is actually, and the main company is in the US. So one other approach that we've taken is to make sure that US company has safe harbor status and has its own data transfer agreements with its own subsidiaries. And we've just made sure that the contractual provisions we have in place between our company and that US company are sufficiently robust to give us the kind of protection and comfort that we need. So it's quite a, they're just trying to give you a bit of insight into some of the challenges we have in terms of protecting, making sure that our personal data is protected when it comes to outsourcing to third-party providers. Stephanie, do you want to?
Yeah, maybe if I can comment on that, because I had a comparable question from a big multinational who indeed had gotten an advice to have a conservative approach, which would lead to a lot of administrative burden, because you can imagine you have all the European subsidiaries, you have a US parent company, you have data traffic, employee data going from all the subsidiaries to the US parent company. The US parent company has a contract with a processor, and that processor has a sub-processor in, for instance, India. So this company had gotten the legal advice that all those European subsidiaries should have direct data transfer agreement with that Indian sub-processor. And so we examined it and we advised not to follow this conservative approach based on the wording of the directive, based on the different European legislations, where we said you have to really analyze the data traffic and look at all the parties' obligations based on that data traffic. So for instance, the Belgian employer sending the employee data to the parent company in the US, the Belgian employer has to make sure that it respects the Belgian legislation based on the directive. And the US parent company has to respect its legislation. Now I think in the draft GDPR it is clarified that all personal data who are transferred from the EU have to be protected based on the EU regulation. So even if the US has a contract with a processor, that's US law that applies, but it has to respect the security measures provided by the EU regulation. But I think that the advice that I gave to that multinational is now supported also by the wording of the draft GDPR, where it is stated that it is very important. So if you go from the Belgian company to the US parent company, that's controller to controller, because it's actually the US company that decides to have a contract with a processor, for instance, a payroll company. And so the US company has a controller processor agreement with that payroll office. And now in the draft GDPR it is stated that the processor is actually the party responsible for any sub-processing. So the processor has an agreement with the controller in which it is stated that it has sufficient security measures, and it undertakes that each time that it would sub-process any of its activities to a sub-processor, that sub-processor has to respect the same confidentiality and security obligations, and it is also stated that the liability of that lies entirely with the processor towards the controller. So that actually supports the advice that the European subsidiaries who have done the data traffic to the US parent company would not need a direct data transfer agreement with any potential sub-processor, because that would also imply that they would always have to be fully aware of which processor, which sub-processors are in the chain. So I think each party has to comply with its obligations and especially secure that information. Yeah.
Thank you, Stephanie. I would like now to open the floor to your question, to all our panelists on all the issues we've been discussing today. We've seen a lot of challenges in balancing privacy in the workplace, namely on the issue of consent. We've seen that there is a lot of issue on data transfer, and it was interesting to see that in addition to safe harbor, Coca-Cola, as many other companies, also adopt model contract laws. Maybe it's an interesting question at the moment where safe harbor is being reviewed on whether or not this framework is actually strong enough or robust enough to offer protection for personal data. And also on the issue of sanction and its link to enforcement. Does any of you have any question for our panelists?
it's related to the entirety of the processing. Yeah. So it should also, what I think there is also an important obligation in the draft GDPR is that the processor should actually send to its controller a copy of all the sub-processing agreements it has entered into. And so the processor and the controller have to keep this documentation available for the local DPAs, but if they have the manpower to look at it. But I think that's it's also a matter of transparency. But it's actually all the obligations that the processor undertakes towards the controller. It has to make sure that its sub-processor for actually the little task that it'll do undertakes the same obligations towards the processor. Yeah.
Thank you. Yes, the issue of DPA's power is also very important.
Yeah.
We've seen also for enforcement, and that's something that the GDPR is looking into very seriously. Other questions for our panelists? No.
Just speak up. Just shout.
Yeah, a bit. I believe that financial data as such are not qualified as a sensitive data, but for instance, so I think that indeed in that event, to the extent that it responds to the legitimate purposes of the controller, those kinds of data can be processed. But the real sensitive data, such as health-related data, I think there the protection is a lot higher. And I think that it is stated in the draft GDPR, but correct me if I'm wrong, that the legitimate purposes of the controller cannot form legal ground for substantial processing of those kinds of data, and that therefore the employee has to consent, or it has to be it has to be necessary for certain purposes, for compliance with contracts, etc., to process those kinds of data. So indeed, I think in the majority of the cases, the legitimate interests of the controller can be a sufficient basis, but it does not apply to sensitive data, real sensitive data, out of which, for instance, certain protected characteristics can be deducted, national or ethnic origin, sexual preference, etc., because those kinds of data, the processing of it, as a general rule, is prohibited, and there are some exceptions provided by the GDPR, but the legitimate interests of the employer is not that kind of an exception, unless in certain circumstances, for instance, the processing of health-related data for payroll administration, for sick leave, and for guaranteed salary payment, etc. So.
Yeah, I think to a certain extent it's of course a theoretical discussion also. In practice, I think in an employment context, and if you look at, let's say, the range of HR issues that arise in a workplace context, in many cases you need those sensitive data in an enterprise, or you cannot avoid them. Also, medical data cannot be, employers need, for example, to be informed about pregnancy of their employees. So in many cases you just, under the existing label, or you cannot otherwise then process data. Of course, there is a question on health data and secrecy of those and confidentiality if you look into the whole sphere of health monitoring and workplace health and safety issues, where you have, of course, medical practitioners who come in, and where there is maybe not so much, let's say, a data protection, legislative protection present, but there are other principles that apply in medical secrecy, for example, that guard and safeguard privacy of the employee in that case, if it concerns health data. If you look at criminal data, I think you get into very difficult sort of balancing also. Let's say I want to recruit an employee in a security function, and I want to do a very thorough background check on past criminal activities or involvement in quasi-criminal activity. Very difficult to say what you can and what you cannot do, what you can collect and process and what you cannot. It's not easy to answer.
Also what you can find, because
and what you can find.
That's a recurring question from our US clients who have a very thorough practice of background checks. And then they come to Belgium, those companies come to Belgium, like the Sterling companies and the background checking service providers. And they ask, oh, can we do criminal background checks? And then we have to say, you're not going to find anything, because that's a fact in Belgium, and I think in a lot of countries in Europe, that those kind of personal data are protected to a large extent. While I was working in the US for a couple of months, it really surprised me. One of my colleagues said that we can look online for the criminal records of employees. Everybody can access those data. It was amazing to me as a Belgian, as a European. It's impossible in Belgium. You have to ask the employee, and indeed you cannot even process those data based on our legislation. So background checks in Belgium, go ahead, but you will not find a lot, I think.
Mr. Google.
Yeah.
Thank you. I think we have time for one last question. There were one question on the right.
As I mentioned before, I mean, okay, it's like school. Yeah, so the focus, certainly in our company, is to engage, consult, even perhaps when we don't need to, with our works councils, our elected representative bodies, not just in terms of policies being introduced, but if there are any proposed changes that may have a material bearing on the business. The culture of our company is very much the works councils, the union reps, the elected representatives are very much part of the engagement with our. They're not a step that we have a tick box exercise. It's very much the serious engagement at European and at local level. It's a commitment that we as a company have made to have good labour relations. So yeah.
I think Walid wanted to add something first.
So there is one point I would really like to highlight before the session is over, which is not one direct topic to the three topic. Well, I think it's related. So I would like to highlight the importance of this privacy at work, in particular, since the way we live and work nowadays is a little different than perhaps we used to work and live 20 and 30 years ago. So the boundaries, I think, between work and life is disappearing, basically. And there are 2 or 3 trends that, well, 2 serious trends and one perhaps like more like a joke. So I think the first trend is, of course, that basically we have this so-called home office. So basically you work a lot at home nowadays, and okay, so how do we deal with the situation? And of course, you have more privacy-sensitive situations and privacy-sensitive data when you work at home. And the second thing is, of course, nowadays we have much more this called bring your own device trend. So, there is basically no distinction between my private computer and my company's computer, but there is one computer and one smartphone that I use for both purposes. And this make, of course, this issue of privacy at work even much more serious and much more difficult and much more challenging than before. And the third, as I said, it's more like a joke, because since we work a lot, and since we nowadays we have a lot of we spend a lot of time in our work environment. We might also meet our partner or our friend or boyfriend or girlfriend also at work, and then also the things, also private life and professional life starts also a little bit to disappear. So as I said, I would just wanted to say that I think there are a lot of issues, and I think there's a lot of research that must be done here. First, to understand this kind of new challenge where the boundaries are a little disappearing, and second, also to develop solutions, not only from the legal perspective, but also, as I said, from the system and from the tool perspective.
I agree that the boundaries are disappearing, and it is different to even 5 years ago. However, it is very important to make sure that the boundaries are in place, and that just has to happen through strong communication to staff and what they can and can't do. There is still responsibilities. So the world isn't as informal as some people might think, and otherwise companies can't function. Organizations they won't be able to protect their company information, their customers' information, and so forth. So everybody's job in a company is still to make sure that the risk is limited and that the boundaries are understood clearly.
I think on that note, we are going to conclude this panel. Thank you very much for coming this morning. Thank you very much to all the panelists in our chair. It was really great to open this first talk of the day. Hope you enjoyed the conference and have a nice day.